The readings of this week were assigned with an eye to expanding on the legal and empirical analyses on the issue of asylum and refugees. We come at this from two angles this week. In the first part, we are looking at the domestic side of the equation, discussing findings from public opinion surveys that address public perceptions of immigration. This section gives us some understanding of why immigration is a high-stakes issue and how various publics respond to the recent influx of immigrants and refugees, especially when facts are manipulated or publics are not well informed about the issues. Next, we take a closer look at legal agreements established by international organizations and accords between states and identify the complexity of such laws as they overlap with the existing customs and immigration regimes and the previously identified political controversy. The European Society's article examines perceptions of immigrant size in Europe and the resulting attitudes toward immigrants by analyzing public opinion survey responses across Europe. They ask whether native residents' perceptions of immigration size are accurate, and whether or not this perception influences attitudes toward immigrants, and whether or not this impact is mitigated by education. They employ a statistical method known as structural equation modeling to identify correlations between variables in the survey. Their analysis takes into account individual level and group level factors, drawing from the existing literature and findings on causes of anti-immigrant sentiment. At the individual level, people who have lower socioeconomic status, or SES, are expected to experience higher levels of anti-immigrant sentiment, while more educated individuals are expected to experience lower levels. At the group level, the authors discuss perceptions related to one's ethnic group's diminishing significance, known as group threat or group conflict theory. By this estimation, groups who feel that their numbers in society have diminished may be more likely to hold anti-immigrant attitudes. A counter-hypothesis holds that groups who live in more diverse settings will hold more favorable attitudes toward immigrants because they have more opportunities to work, learn, and live with people who are outside of the dominant group culture. Some research has backed up the contact hypothesis, but much research in the United States related to immigration points to increasing immigration leading to greater prejudice. The authors test the importance of perceived size of minority populations, basing their approach off of previous findings. For example, German respondents in 2004, on average, estimated that 15% of the population was foreign-born, while the real number is actually around 8%. Other studies have largely found that individuals in Europe overestimate the number of immigrants living in their country. In addition, they draw from the U.S. study that was also assigned for this week, which explains that miscalculations of immigration population size are due to media influences, residential segregation, racial stereotypes, and perceived threats. The U.S. study found that negative attitudes toward immigrants are significantly impacted by gender, education, and age. In this study, older, more educated women were less likely to overestimate the size of other groups. In addition, the more accurate respondents were about the size of the population, the less negative were their attitudes toward immigrants. The authors used data from the Organization for Economic Cooperation and Development to obtain the real size of the immigrant population, unemployment data from the United Nations, and Eurostat. This is a clearinghouse for European Union data. They formulate variables out of survey responses about immigration in 17 Western European countries, ending up with a sample size of 33,186. Using SEM, they estimate the correlations between perceived immigration population size and prejudice as dependent variables. They use SES, gender, the real size of the foreign-born population, GDP per capita, mean unemployment, and change in unemployment as independent variables. This graphic illustrates the hypothesized mechanics of their paper. They hypothesize that the real size of the immigrant population has a direct impact on prejudice, but that the perceived size may also have an impact. This slide offers a more complex view of the mechanics that they hypothesize. Anti-immigrant attitudes are represented by the center circle, and the arrows indicate the direction of the influence by the independent variables represented by the left-hand column. The size of the population has an influence on the attitude toward immigrants, along with the other variables that they use to tap hypotheses about macro influences. But we also see a separate path of influences coming from individual variables to influence anti-immigrant attitudes. attributes. These include age, gender, education, employment status, and so on. Moving to the right of the diagram, the various indicators of anti-immigrant attitudes are enumerated. These include concerns over job competition, welfare spending on foreigners, economic woes, cultural threats envisioned by immigrants, and crime concerns and stereotypes. In Table 1, we can see that respondents in every country that's analyzed gave an estimate of foreign-born population that's higher than the real number. Sometimes this varies wildly. For example, Italy only has 3.93% foreign-born in the year represented here, but the perception was that 17% or more are foreign-born. The variable misperception 1 measures the actual percentage points of the difference between the perceived size and real size, while the misperceptions 2 variable measures the misperceptions as a proportion of the real size. In Table 2, we see the results of the structural equation models of determinants of anti-immigrant prejudice. We pay attention mostly in these tables to the beta coefficient, which is the regression line, and also to the asterisks, which tell us whether or not the probability value is greater or lower than 0.05, 0.10, or 0.001. This refers to the probability of finding these relationships by chance. With a negative coefficient and a p-value of 0.001 or lower, education is negatively correlated with anti-immigrant prejudice. This means that more education of a person makes them less likely to hold anti-immigrant views. Perceived size and age are positively correlated with anti-immigrant prejudice. In addition, female gender, urban residents are negatively associated with anti-immigrant prejudice. However, age, gender, urbanity are not statistically significant, so the authors would have to reject these hypotheses. Financial problems were another aspect of individual variables that were positively correlated with anti-immigrant prejudice. Interestingly, having immigrant colleagues is statistically significant and negatively correlated with anti-immigrant prejudice, but the real size of the immigrant population, while negatively correlated with prejudice, is not statistically significant. This slide contains information about asylum numbers in Europe in 2015. The main purpose of this short article on asylum in Europe is to outline some of the national and supranational level regulations on asylum seekers. Because the EU entails a number of agreements on immigration, trade, environmental issues, and financial laws, the question of asylum requires some level of coordination between member countries. Because of their proximity to the Mediterranean, European countries are often sought as refuges from Middle Eastern countries, and the region has seen an influx of Turkish, Syrian, Libyan, and Tunisian refugees, as well as other places. In response to this influx, many European states have moved to make labor force participation more difficult in the hopes that refugees would choose to move on instead of staying permanently. The EU decided to adopt organization-wide rules that would lessen the impact of these rules beginning in the 1990s. The EU regulation, called the Dublin Regulation, states that the EU country an asylum seeker first enters is responsible for processing his or her asylum application. As most asylum seekers enter the European Union over land or via the Mediterranean Sea, the countries in the south and southeast of Europe, Greece, Italy, Malta, and Spain, are responsible for most of the asylum applications in Europe. Countries in the community with no external frontier should therefore have relatively low numbers of asylum applicants, as they can return asylum seekers to the country where they first entered the EU. Serious concerns regarding the Dublin procedure emerged, especially at the point when the European Court of Justice ruled that a refugee should not be expelled to Greece due to inhuman living conditions for refugees there. At that point, most European countries stopped expelling refugees to Greece. In addition, there are European regulations like the Qualification Directive and Asylum Procedures Directive designed to enforce a minimum standard that can be claimed by all refugees, no matter which European country they find themselves. These standards are also implemented into national law in the EU member countries, but they are drawn from UN covenants and declarations. Some countries have regulations that go beyond these directives and are actually in favor of asylum applicants. The Qualification Directive distinguishes between two types of international protection: refugee status and subsidiary protection status. Asylum seekers who do not qualify for refugee status but would risk serious harm if they return to their country of origin can obtain subsidiary protection. So, subsidiary protection status again refers to a third country national or a stateless person who does not qualify as a refugee, but in respect of whom substantial grounds have been shown for believing that the person, if returned to his or her country of origin, or in the case of a stateless person, to his or her country of former habitual residence, would face real risk of suffering serious harm as defined in Article 15. This could include the death penalty, torture, individual threats, or threats of armed conflicts. Some countries have adopted standards that go beyond, but Denmark, Ireland, and UK have opted out of the directives and are not bound by these minimum standards. National asylum law regulates all aspects that are not determined by European directives or where the implementation of directives allows for flexibility. It is also possible to deviate from the above EU directives as long as standards are established that are more favorable for asylum seekers than the conditions stipulated by the directives. The Qualification Directive states that refugees granted asylum are able to receive a residence permit that is valid for at least 3 years and is renewable. Persons granted subsidiary protection status must receive a residence permit that is valid for at least 1 year and renewable for at least 2 years. Only a few countries grant resident permits that are valid for longer: France and Sweden. Sweden issues unlimited residence of refugees and subsidiary protection status persons, whereas France offers 9 years. The directive stipulates that a refugee has the right to participate in the labor market as soon as he or she is granted asylum. As asylum procedures take some time, however, a crucial point is the right to work already during the time of being an asylum seeker. As the European directives do not cover this topic, it is only dealt with by national regulation. Each country has a different regulation about requirements for getting a work permit. For example, in Germany, you have to have a job offer and you must complete a priority review, which establishes that no native person could do that job. In Sweden, a person only has to have valid documents establishing identity to get a job. The main thrust of this article is that while there are regulations from the EU regarding refugees, there is a lot of room for sovereignty to play out and create massive differences in policies toward them. There are a lot of logistical and legal complexities around the issue of asylum, and the route that asylum seekers take to their ultimate destination can involve multiple states, which raises the question of which states have responsibilities to process the asylum claims. When a refugee asylum seeker finds temporary refuge in a country that is not their intended final destination, this is referred to as a third country. While this is confusing, it's easier to think of asylum as an ideal situation that would involve a conversation about or between two countries. That would be the country that a person is leaving and the other one that a person wishes to enter. But this third country is for some reason or another part of the path and part of this conversation. This is cause for concern because these countries often lack the resources to provide for large refugee populations, and they have been historically absorbing a disproportionate share of this population. In reality, the countries refugees would like to enter most hold a tiny proportion of the world's refugees. Therefore, while Europe and the United States are highly sought after, the majority of the world's refugees end up in their neighboring countries. Because the vast number of refugees come from developing countries and developing countries have regional proximity, the global south, this is almost logical, but the belief that Europe and the United States shoulder all of the burden persists. The developed countries have created many institutional and procedural barriers that keep refugees out of their countries. Rules like the safe third country and first country of asylum, as we read about in the EU laws, keep richer countries shielded from these larger numbers. The provisions for returning asylum seekers and the regulations about them are expounded upon here. In the EU, the Commission proposed harmonization in 2002, the act of states basically creating similar national laws around how to return refugees to a previous country. The United States entered into a multilateral agreement with its neighbors in 1996 and an additional bilateral agreement specifically with Canada in the same year. This procedure has been occurring since World War II, and most recently the United States has conducted bilateral agreements with Guatemala and Mexico over Central American refugees. Governments usually envision readmission agreements first and foremost as border control strategies. The goal is to facilitate the return of people who have entered their territories or remained irregularly. But asylum seekers invariably are part of any large irregular secondary movement and are affected by these readmission agreements. The UN High Commissioner for Human Rights prefers this method over the safe third country legal diversion. States also form readmission agreements with each other, agreeing to admit certain individuals at the request of the other state, especially their own nationals. International law attempts to address which states are responsible for the legal processing and thus the resource provisions necessary for asylum claims. Most countries abide by similar rules in the harmonization effort. If family reunification is possible in the country a person wants to seek asylum in, then the claims are often processed more easily. There are exceptions, as in cases where an individual is already in the country and has been for some time prior to applying. However, this is where most of the similarities end. There are different policies for which claims take priority, which states are considered safe, and proving where someone entered the region is often difficult, except in some rare geographical circumstances. Finally, there is a lot of labor and financial resources required to process claims, assess needs of claimants, and track their progress through the system that finds them jobs and housing. The agreement between the United States and Canada involved the United States agreeing to take back most refugees that entered Canada through the U.S. Even in the early 2000s, around 70% of asylum applications in Canada entered through the U.S. Around 15,000 people apply for asylum in Canada after passing through the U.S. per year, but only about 200 per year do the reverse, try to enter the U.S. through Canada. The imbalance at the time of this article's writing was attributed to a higher refugee recognition rate in Canada and more favorable conditions, especially fewer detentions. As of July 22nd, the agreement is now considered invalid after a ruling by a high court in Canada stated that the U.S. was no longer a safe country. So some of the problems include the issue of orbits and chains. There are certain countries that tend to be caught in the middle of this due to their geographical proximity to some sort of human rights calamity taking place. The issue of chains involves family reunification. It is a difficult issue, but family members tend to move and follow one another in these asylum claims. It is difficult for the violations of human rights to be addressed when they are occurring in some of these interim stops along the way as well. So these are some issues that are important, as well as some countries lacking the resources to process the claims and provide for these countries. Unfortunately, those countries tend to be the ones who are receiving a disproportionate share of refugees. A few things remain to be discussed, which we will talk about in our live session on Wednesday. This includes the status of asylum seekers in the United States today. So on Wednesday, we will look at some of the numbers related to that and our own national political debate about the question of asylum. We will also discuss the problem of children seeking asylum without their parents and also discuss updates to refugee numbers that are related to COVID-19 slowdowns.